The federal government has recognized the need for comprehensive reform in the criminal justice system. To meet this need, a wide-ranging series of proposals called Directions for Reform, Sentencing, Corrections, and Conditional Release were released for discussion in July 1990. Following extensive consultations, Solicitor General Doug Lewis introduced the Corrections and Conditional Release Act in October of 1991. The act was adopted by Parliament in June of 1992 and was proclaimed law in the fall of 1992. The Corrections and Conditional Release Act contains significant measures to reform correctional legislation to better reflect the values and concerns of Canadians. Above all, these measures assert that the primary duty of the correction system is to contribute to the protection of the public. The new law responds to a number of long-standing concerns. These include the need to reduce reliance on incarceration for less serious offenders, the need for more predictability in conditional release decision-making, and more stringent measures for those offenders who are of greatest concern to the public. It also addresses the need to make the criminal justice system more open and accountable, as well as ensuring that its components, the police, judiciary, prisons, and parole boards, function effectively together. In this video, we'll outline some of the major changes that will take place under the new Act. Where previous legislation was silent on the subject, the new Act stipulates that the protection of society shall be the paramount consideration in the corrections and conditional release process. That principle is the cornerstone of the Act. The Act acknowledges that corrections involves a continual assessment of risk to ensure the public's protection. Therefore, all relevant information about an offender, including the recommendations of the sentencing judge, information from the Crown Attorney, the police, provincial correctional services, victims, and even from the offender, is critical in making decisions. And to ensure effectiveness, this information must be shared among the components of the criminal justice system. For the first time, victims of crime are formally recognized in federal corrections legislation and included in the correctional process. Victims of crime may, on request, have access to information throughout an offender's sentence, including dates and destinations of any temporary release, dates of hearings, and the status of parole decisions. One of the strong recommendations made by many experts in the reviews leading up to the introduction of the new Act was the need for greater sensitivity and emphasis on the needs of special groups of offenders, particularly women and Aboriginal people. Under the new Act, consultation with women's groups and others will be used to help design appropriate programs for female offenders. Native communities will be able to be more involved with Aboriginal offenders. Native spirituality and spiritual leaders will have the same official status as other religions and religious leaders. Probably the most important reforms in the new Act are those dealing with conditional release. This includes temporary absences and various forms of parole. There are a number of changes here reflecting the desire to protect the public from violent offenders. At the same time, the system will be streamlined to get nonviolent offenders back into the community to get on with a productive life. Conditional release is part of the overall sentence. A paroled offender will remain on parole for the length of time left to serve on his or her original sentence, provided, of course, that the offender abides by all the conditions of that parole. The new Act allows judges authority at time of sentencing to set parole eligibility at 1/2 of the sentence up to a period of 10 years for violent and serious drug offenders. However, nonviolent offenders who are serving their first penitentiary term and who the parole board consider unlikely to commit a crime of violence before the end of their sentence can be released at the 1/3 point in their sentence under a provision called accelerated parole review. Again, the protection of society will be the primary consideration. For all offenders, eligibility for day parole will now be at 6 months before full parole eligibility or after 6 months of a sentence, whichever is greater. This represents no change for offenders serving sentences of 3 years or less, but those serving longer sentences will spend more time in prison. The new act sets out criteria regarding escorted and unescorted temporary absences by inmates. Temporary absences may be granted for medical, compassionate, or administrative reasons, as well as to allow prisoners to maintain family contact and carry out parental responsibilities. All inmates are eligible for escorted temporary absences at any time during their sentence. Most of these absences are granted under the authority of the Correctional Service. Those serving life sentences for first and second-degree murder, however, must receive approval from the National Parole Board. The criteria regarding unescorted temporary absence will be tightened for offenders convicted of crimes of violence or serious drug offenses. There will be no unescorted passes for inmates classified as maximum security. The Act also introduces new types of temporary absences which allow offenders to participate in voluntary community service or personal development programs outside the penitentiary. Among these are a new work release program which will allow medium and minimum security inmates to work at jobs or projects outside the institution under supervision. Up to now, inmates in federal penitentiaries were able to earn time off for good behavior. This was called earned remission. Inmates could earn as much as 1/3 off the time they spent in prison, but this system was overly complicated and difficult to administer. Under the new Act, the practice of earned remission will be abolished in favor of statutory release. Statutory release means inmates will be released into the community at the 2/3 point in their sentence and placed under the supervision of a parole officer. While on statutory release, they must abide by the same conditions as those on parole. Failure to do so could result in suspension or revocation of statutory release. Statutory release, however, does not apply to lifers and those serving indeterminate sentences. Those inmates whom the parole board consider likely to commit an act of violence or a serious drug offense before the expiry of their sentence can be detained in prison until the end of their sentence. The new Act requires the National Parole Board to maintain a registry of all its decisions. The purpose of this registry is to promote openness and accountability in the Parole Board's decision-making. The registry will contain all parole and day parole decisions and the reasons for them. It will include all decisions on parole suspension, revocation, recommitment to prison, and detention. And it will include any decisions made by the Appeals Division of the Parole Board. The registry is open to anyone who has an interest in a particular case and requests the information in writing. This includes victims and other members of the community, such as researchers, students, or journalists, who may have access to the registry for general study. However, all names and identifying information about offenders will be removed when the registry is used for this purpose. Information held in the registry may be withheld if personal safety or a confidential source may be endangered, or the information may adversely affect the successful return of an offender to society.
Another significant change regarding the National Parole Board is increased public access to parole hearings. Victims of crimes and other members of the public, including the media, may be permitted to attend parole board hearings as observers, provided they have prior approval from the National Parole Board.
Observers will not be allowed to take part in the proceedings, but where the observer is a victim or close relative of a victim, he or she may submit information in writing prior to the hearing, and the board will consider it. The parole board may exclude observers if it decides their presence would in any way disrupt the hearing, jeopardize security at the institution, prejudice a fair decision, or interfere with the offender's successful return to the community.
The parole board will consider, but does not have to follow the offender's wishes about the attendance of observers.
Finally, the new act establishes the Office of the Correctional Investigator in Law. The correctional investigator is an ombudsman for federal offenders. The investigator's legislated mandate will be to investigate all matters concerning the activities of the Correctional Service of Canada. Up to now, the correctional investigator's mandate has been carried out under the Inquiries Act. Ultimately, the new Corrections and Conditional Release Act is designed to modernize Canada's correctional and parole system, to help make the criminal justice system more open and accountable, and to make it more effective in managing the sentences of the courts, contributing to the protection of society, meeting the needs of offenders through professional programs and services, and actively encouraging and assisting offenders in their reintegration into the community as law-abiding citizens.